another exciting edition of the ESG Practical Lawyer webinar series. My name is Jessica Ikene. I'm the moderator for today's webinar. At ESG Training Limited, we provide comprehensive continuous professional learning with courses and training across various areas of practices. We have tagged this webinar series the Launch Our Webinar Series, and it is slated to hold at 1 p.m. during lunch break every Tuesdays and Thursday, respectively. After every section, we provide the resources in easy, accessible format on a go for everyone who is interested. And today's topic is intellectual property challenges in business transactions. And some of the things that will be discussed are creating valuable IP, managing IP portfolio, nuts and bolts of due diligence, managing IP portfolio, artificial intelligence as assets in business transaction, and also dealing with IP lawsuits. If you do have any question while the webinar is going on, please do type in the Q&A and to be answered in due time. It is with great delight I introduce our speakers for today. We have Mrs. Uche Wokocha, who is a partner, welcome, sir. Welcome, sir. Okay, we have Mrs. Uche Wokocha, who is a partner at Alukoyo and Oyebode. She'll be speaking on creating valuable IP. We have Mr. Adebayo, who will be speaking on the nuts and bolts of the due diligence, and is going to be our second speaker. We have Mr. Otu. I hope I pronounced that correctly. He is the legal director at Olajide Oyewole LLP, and he will be speaking on IP portfolio, artificial intelligence and assets in business transaction. And we have Mr. Folari, who will be speaking on dealing with IP lawsuits. Okay, our first speaker is Mrs. Uche Wokocha. Please, over to you, ma. And yes, I'll be sharing your slides. So,
thank you. I don't know if you're having problem, I can start and then we can share the slide when you are able to. It's up to you.
Oh, I think the ESQ representative just left.
Oh, she was meant to share my slide, but then I wonder how, for the benefit of the audience, I can go on and just speak, if that's okay.
I think so.
Okay. You're on the screen. You're on the screen.
Yeah, if you click away from I think you pinned me down.
How? Okay. So do I click on my name? Because it's supposed to be where I think we need her to get here. If I couldn't do that, I'm trying, unless if I click on my name, that won't even work.
I'm trying to search.
Okay, let me send her a chat. I'm surprised.
Ah, she's back. Okay.
Okay. Do you have problem sharing my Do you have problem sharing?
The internet. I'll do that right now.
Okay.
Sorry about that.
Okay. Can you join and share? Are you able to share? Yes, because you're having problem with the internet. She did it. Awesome. I wonder whether this is okay. Okay. Good afternoon.
My screen.
Yes, I can start, right?
Okay, yes, you can start.
Okay, so if you can move to slide 1. Can I control it? I can't even. Thank you. Thank you everyone for joining today. There's hardly anything I can tell today's audience that is new, because I am speaking to an audience filled with intellectuals. Nonetheless, thank you so much for joining. So if a man empties his purse onto his head, no one can take it away from him. An investment in knowledge always pays the best dividend. I can never overemphasize the value of intellectual property, because it's what you have in your head. Even when you are at work, what you have on the file, it's what you have on your head, in your head, it's not even in the files. So all those experience, the years that you were mentored by a good boss, and all the personal developments you embarked on, like doing trainings and going on trainings and paying for them yourself if the office is unable to send you. All of that knowledge are things you have, and it goes with you. And there's a reason why it's said that some people are good tax advisors. There are so many tax advisors. There are some that will really, without breaking the law, will advise you on the best way to minimize the tax you pay, and advise you and ensure that they claim all the benefits, that is attached. So that's my introduction. If you could go down, because no, apart from that, I had said somewhere that a growing list of investment, because today we are talking about the importance of IP with respect to transactions and today's investment portfolios. So a growing list of investment structures are designed to capture IP value. For instance, if you go to the bank to loan you money. If you're like a new company starting up, and you can't go to the bank and say, okay, they should give you money because you have intellectual property, because it's intangible, they can't see it. So it doesn't make sense. They will not give you money. You would have to bring something that is attached to that IP, either the product, for instance, iPhone. I don't think the only thing that made iPhone very popular is the gadgets and all the security that is attached to it. For using your own in a battle, you'll be alerted that somebody has attempted to either open for instance, you have an account with Apple and they say somebody is using your account in Abeokuta or Ibadan, so those are the things that really gives you the value, not the fact that your Apple Inc. or that you have an iPhone. It's what that product does, because every intellectual property, for instance, is attached to a product. That's what gives it value. Without the product, it will have no value. Take also, for instance, patent. You have patent, you registered it, it is yours for 20 years, but you don't go about saying you have patent until you manufacture something, maybe pharma companies, and they're selling their pain relieving tablets or tablets for HIV or even COVID, the vaccine, and all of that. So that's what gives you value, not just the word. You need to apply it to a product, and then that's when it gets value. Next slide, please. I realized that today that I cannot really talk about intellectual property without distinguishing trademark and brand. Today, it is known to everyone that brand is the way to go. It's all about branding. We have brand ambassadors, and if they shine your product well and then use it in a way that it brings value, then your product will go up. So we have all of those. So once a trademark identifies origin, it's an indicator of origin to say that, for instance, if I have a logo and I put it in my trademark, this is me. This is my product, and then you know how to trace it back to me, because it indicates that this is the Coca-Cola, and the product belongs to Coca-Cola. The brand on the other side, yes, has gone further, to give you value. For instance, an effective brand strategy, because it had to do with strategy as well. You need to strategize. How do we build on our brand? It doesn't happen overnight. I have people in my family that have used a particular hand cream for 20, 30 years. They keep it by the sink. They believe in it. They can swear by it. They can die by it because it works for them. And the moment somebody goes to counterfeit it and it starts working, then they start screaming. Either if they're loyal customers, they get back to the brand owners, or they move to the next available good one. So for instance, Amazon is just a brand that is known all over the world. It became even more well-known during the COVID lockdown. Their logo signifies smile. It's like an old man in the village during the Harmattan, and they're cold, and the sun from America sends Amazon, and it's just a cardigan. You can imagine the kind of smile it brings to that man's face. Or maybe the children brought him drugs from America because nobody is traveling and the man couldn't travel. And then the children now got the drugs and sent to him. You flash a smile. So that's what Amazon stands for. So brand tells you what to expect from the brand owner. And then it's a promise to deliver. The brand owner is telling you that this product, I promise that will deliver exactly your expectation, and even in some cases, exceed your expectation. So what are people saying about your brand when we are not there? It speaks for itself because it's good. Remember when we used to have peak milk, some people will complain that, oh, if you buy the peak, it's thick. So if you put it in your tea, so it's likely to color your tea better and faster than ordinary milk, other milk. So these are all about branding. It's what you want your people to believe that it is, what you want them to expect it to be. You need to keep that measure of expectation and you don't go below. Next slide, please. So today, today's theme is all about creating value for your IP, how you can use it for investment, and then how some of us students and even business owners, some of us that are business owners, how many people in the boardroom know about intellectual property? When the commercial people come, they tell you, so what is the money worth, the value? That's what they want to see. They don't want to know that you want money to promote your brand. They're not looking at that. They're looking at the bottom line. So, but if you commercialize your intellectual property, it gives it an edge. So IP as in an intangible asset can also qualify as subject of trade, thank God, for reasons below. So you can commercialize it through licensing. I will discuss it as a whole subject in the next slide. But then licensing, it's one. Co-branding. We have been seeing in mobile filling stations, you see Mr. Biggs. They started with when he was in score. They had the ins and they have the creamy in. So it was like a portfolio that was sold to UAC Nigeria by a company called InScore. So it's a sort of franchise. And then without even going into franchising, let me just say the co-branding is when you have two brands, usually a senior brand and a junior one. So the senior one is trying to bring the junior one into the foray just to show, to introduce them. And after they did that, USC has since run with it. Look at, you have Mr. Biggs everywhere, you have mobile filling station, that's co-branding. Then franchising that I briefly mentioned, whilst the difference between franchising and licensing is whilst the licensor, that's the owner of the trademark, is licensing just the trademark to you, with franchising, it's actually allowing you to use their company, the name of the company. So that's why brand owners are very weary of franchising, because it's usually for a long period, usually 10 years, some of them that I've done, because you need to involve even NOTAP to be able to allow you to take your proceeds home. So it's like a long project, 10 years. At the end of it, you find out that the franchisee will fight you to get your name back, because he now tells you that, oh, in this jurisdiction, they know me with this name, I've grown goodwill, so you can't take it back. So it's an issue that, you know, that brand owners really have difficulty in franchising. And besides, with franchising, if for instance, you remember when it wasn't McDonald's, but the, which one now? I'm not too familiar. Well, you know them, they are in TBS. So it's the chicken one. So you remember when they came to Nigeria and all that, you use the name and then people will come and eat it and then say, oh, no, it's not like KFC here. Because what you're selling as a franchise is your taste, everything about you, even the decor of the, they will use the get up. If their brand is red, that's what you use. So that anybody walking in London into KFC will walk in here and it's the same, everything is the same. Then securitization is where IP really can have, the value of IP can be seen. And when do you start seeing value? Maybe you sold your portfolio of IP and then you use it, the bank, you can use it to take loan. In some cases even, there have been issues now in insurance, which I will discuss when I get to the key takeaways. Insurance is a new area that is coming because there are judgment debts, there is litigation. Sometimes you need to insure against all of this. So that gives you money, the insurance that you expect, future payments and all of that. So these are the ways to commercialize your IP, an assignment where you'll also assign. If, for instance, I'm a brand owner and I'm not using it in Nigeria or in Ghana, I can assign it to somebody to use and pay me money. So instead of leaving it dormant. So that's a way also to make money. I've talked about portfolio acquisition and royalty acquisition. If, for instance, in a franchise deal, you will now have the franchisee paying you monthly royalty, a percentage of your profit every month from sales, for instance, in the mobile and the UAC deal. Next slide, please. Licensing. So what are the steps? Steps to consider. First, you know who your licensee is. Remember, you're probably coming from offshore to come and do deals in either Ghana, Nigeria, or South Africa. You do not know this licensee. So these are the initial steps. You do due diligence, know who this person is, what kind of business they're in. If, for instance, he is selling baby food and he wants to be your licensee for cosmetics or chemical products, that doesn't really work. So these are the steps you take to check out and factors to consider. This man, how his integrity, the businesses he has done in the past, who can vouch for him? Is he the kind of person that will take money and just disappear and go to Bahamas? You know, so you need to check all of those. Then all the risks, you look at the jurisdiction. You'll also, I tie it together with jurisdiction. You know, for instance, in Nigeria, our regulators, people are afraid of NAFDAC, NOTAP, and SON. So they tell you, brand owners will tell you that coming to do business in Nigeria, it costs so much money and all of that. So you look at what the potential risks are. Those are the things you do. If you are a lawyer who is retained to help in the transaction, you need to get all of those so that there's no surprises. And then who the prospective licensees, like checking them out and knowing how many, then you can decide, narrow it to what. And then used by licensee. You don't want a licensee that will go about using your brand anyhow they like and bring the value down. It's either that they get up when they want to use. I remember how Coca-Cola will always say that if you write their name, Coca-Cola, you must put that hyphen. Some people just write Coca-Cola, you don't. Things are important. For some of the Chinese brand owners we work for, we'll get a certificate where the registry will make a mistake and not put dot, maybe after ink. They send it back. So these are things like that. Is when you say that you have a brand, you need to respect your brand. You need to look at it, which is also the concern I have with brand ambassadors, because sometimes they go about saying things that will be traced back to the brand owner and will hurt the brand. Next slide, please. Valuing your IP. So it's simply called valuation. So traditionally, it's valued by one of the three methods. The first one, market value. So you look at the product in the market and then see the cost of similar product. For instance, I always use iPhone and Samsung. You know, it's like competition. People that use iPhone will die for it. It's like a code. People that use Samsung will stick with Samsung. So you look at that, the market value, to compare, you know, the cost of both, if they are par. And then also the technology, if you're involved in software or patents, you look at similar technology or comparable one. And I will jump to the cost. The cost of IP, the cost approach is also looking at the cost to replace the product. If it goes bad or it spoils, the cost to replace it. So you need to look at all of those, the investment that was put in, the total cost, the money and everything. So you need to know the cost of replacement. That's what the cost approach is all about. Next slide, please. The final one is the income approach. This is the one that people use. I mean, this is the one that really makes more sense because it has to do with royalties and future earnings. You project your assets. I remember when we did IP evaluation for a Moment with Mo, and they were trying to get invest money from the bank. Then we needed to really, in writing it, you need to argue and justify that this company, they have been running Moment with Mo. That time it was like upwards of 10 years. So if they were doing it on a yearly basis, look at the projection, and they've done well. Therefore, they can do the TV, the Ebony TV, you know, all of that. Then from there, and we have seen her growth since then. So these are the things you look at. We always try to look down home. You could have looked at Who Wants to Be a Millionaire or all of those things that they do overseas, or Britain Got Talent, but we narrowed it and did our own. And Nigeria is really a good jurisdiction for business. Brand owners tell you that this is the place because of our population, everything sells here. So if the government will take intellectual property and the banks will give intellectual property the kind of value it deserves, you will find out that businesses that will attract investments into Nigeria. Next slide, please. Digital assets. Do you know it has been forecasted that by year 2030, that digital assets will attract the kind of income that has never been seen, maybe since after the Second World War, thereabout, before they started having all this inflation, all the years that followed. So this is the way to go. And it has often been said that companies that do not invest in innovation will simply die. Look at Kodak. They could have done something with their myopic camera until the phones came and started, using the phone to take pictures. Look at Netflix. Netflix approached the, what did they call it now? I can't quite remember the name, but it was the movie thing that you hire. I know that's so common in America.
Blockbuster.
Thank you so much. So they approached Blockbusters to buy them, they ignored them. And I wonder what that's where he is now, how he'll be biting his finger if he looks at Netflix today. So you find out that most managers are, when I went to Harvard, I remember there was a course that the professor took and called it, he says, explore and exploit. People exploit, but they don't explore. So when they get to the head of the cliff, a manager, he fails to jump. Because if you jump, you don't know what to find. But the risk takers, if you jump really, you find out that that's what is happening with today's innovation. Everybody is trying out things. Some companies are dying off when others are really going. Years back, there was a survey that was done about the best 50 companies in America that are thriving. Amazon was number 49 or 48. Today, he's the first 5. And Coca-Cola, that was number 1, has dropped. So this is all about trying out new things. You need to, because if you don't, you simply die off. So digital asset is the way to go. Look at the, even coming to Lagos, you see the e-tag, you see the Google Maps, the likes of that. Somewhere even in Asia, I read somewhere that in Asia, a particular Asian country, they use these digital assets or digital gadgets to monitor crime rates in a particular community, and the crime had reduced. So things are really changing. Look at today's market, things are happening. Is it the SpaceX or is it the Blue Origin? They have even gone to the space. That's a special committee have been formed by the INTA, the International Trademark Association, to discuss IP in space. That tells you the value of intellectual property. It's actually the most valued asset a person can own or a company can own. Your assets, okay, for instance, a law firm, your asset is not in the desk or in the files, it's in your head. The associates, the partners you have that are writing opinion and are earning fees for it, and all the partners that probably specialist area, IP is a specialist area, another specialist area is tax. So these are the things. Or you come to the hospital. You think it's when you go to the hospital and come out. The human capital, they want you, they want more people, because if you don't go to the hospital, they die off. I mean, how do they pay staff? It's by you coming. Plus they use your data because they collect all that data for you. Where do you think the telecom companies or market telemarketers, as they call them in America, where do they get your information? They've started it in Nigeria. I'm in my house and somebody is sending me and telling me to come and buy grocery, or actually that if I want it, it can be delivered in my home. So it's all about digital assets and data and all of that. Next slide, please. So monetizing data, I mentioned it, which is what also they do with the airlines and the hotels and Netflix. If you subscribe to Netflix, now you know that oftentimes they come to you and suggest movies because they know you, they've got into your psyche, they know your behavioral character, the kind of movies you like. So they will be suggesting because they know you. So all of those, and then with the airlines, and then even with the insurance, or even coming nearer home, when we get our licenses, our international passport, the government, they have. I remember when I went to renew my passport and the immigration officer said to me, oh, you have not changed your phone since. You see, they have all the information. They know when you've changed it. Oh, you've been in one office address for so long. You know, all of that. They have your information. That's what data is all about. And even like the esports now, it's the future of sports, because even as they do that, it benefits brands because they wear those gadgets, BMW and Tesla and stuff like that, to play. And then how do they do that? It's even free. You can watch it, it's free. It happens in the audience, you find people that are actually playing the particular sports in real life, and they want to watch it to perfect. So it's like a learning thing for them to improve on their sports and then play. And then if you go to the stadium, usually it's gated. You can't go in if you didn't pay. But this one, you can, in the comfort of your home, watch it. So this is the way. And who are the target audience are the young people, because that's the way they want. Everybody's online. Everything is happening online now. So digital assets are really the way to go now. And of course, the AI is also the machine learning. I mean, the AI is doing so much and it's faster and it's more accurate. So you can put it and it brings it out. So it's really, the whole world is changing and becoming better. So where, for instance, in counterfeiting, you're probably trying to chase and see how many people are selling it. AI will draw them the list and give it to you. And where, for instance, you're probably filing a trademark and you're writing your logo or designing your logo, sometimes you can make mistakes because you're human, but AI will spot and some of the benefits of digital assets. Next slide, please. Okay, so that brings me to the hottest product now. Apart from the blockchain and everything, NFT stands for non-fungible token, and it's a digital asset. So what you do, you get a certificate that you own this. But the good thing about it is not counterfeited. So it's very difficult for somebody to counterfeit it. So while people will have their paintings in the house and all of that, so you have it digitally. I give an example of these are siblings, and then the Charlie bit my finger video. It's over 20 years or thereabout. They are now about 20 something, but when this happened, they were toddlers. They're probably 3 and 4. And this painting was auctioned and it fetched thousands and thousands of dollars. Let me not exaggerate. So that tells you the way we are going. And now I wasn't surprised when the former First Lady, Mrs. Trump, came and said, oh, show the picture of some of the clothes that she wore, NFT. So that's what it is. You know, so it's the way to go. Digital asset, things are happening online, but we have to be careful because as they're happening, counterfeiters are also chasing every good thing you have. They make a counterfeiter of it. Okay, finally, I have key takeaways. And number 1, maximize the value of your IP. How do you maximize it? Commercialize it, and by pursuing even the modest sources of third-party revenue through licensing. Everything counts. You could really see that everything counts. At least it can help you with the revenue and then with expenses at work. So you must not leave any of your intellectual property dormant at any given time. You know how you have dormant accounts and the banks will call you and say, revive it. That's the same way. You must really check, have a catalog of all your intellectual property, and then see how you can license, assign, or do something with it instead of letting them just stay. And then data is only as useful and valuable as the decision it helps businesses to make. You know, they say big data, and they're actually like a lot of companies are sitting on data, not knowing what to do with it. So it doesn't have value if you don't use it. So there are a lot. So all of these companies will just have to look at it, because if you don't use it, then it's not in your balance sheet as an asset, it's underutilized. That's how they keep saying that IP, if we are discussing ways to create value for intellectual property, these are the things people should look at, business owners. And then, of course, the intellectual capital is an informal IP. It's a new area. It's not usually on the balance sheet, but then it has much value. What are the intellectual capital? I'd mentioned human capital, it's all part of it. Then trade secrets is one. Research and development, organizational knowledge. When I mentioned about in the company, you have your lawyers writing opinion here and there and in fees, and amongst others, the know-how also. You find out that sometimes somebody wants to leave a company, they said for the person to sign an agreement, non-disclosure, because they master the know-how of this company and everything. They don't want them to go on and then sell it to their competitors, so they'll continue to make profits. Then strategies and market intelligence. It is also very key, because before you go into a market, you check and see what, scarcity is tied to value. You need to check and see what is scarce, an area that has not been tapped by others, and you want to just tap that area. So these are all part of strategy. And then critical suppliers and customers. There are suppliers that are good. There are suppliers you even enter into an agreement and they give you credits ahead until you sell them. So all of those, and then they're critical to your business. So you look at all those and people will look and say, why is his business thriving? It's because he knows what he's doing. He has these suppliers that are loyal, that will not supply to somebody else, will only supply to you. So these are all part of the strategy. Then, of course, insurance is the new area. I'd mentioned it briefly. There was a tech company in America that was awarded $500 million. And then the people that lost appealed, but they took out insurance for $250 million, at least ahead of that judgment debt, So there is no way, even if they don't get the 500 million, they must get something. And then the fact that they have this insurance, it might take a long time for the matter to be finally determined, because after that, they probably keep appealing. But it covers everything with this insurance except settlement. So there's an agreement, you say, but insurance is a good area that is not coming into intellectual property and give you the added value that is required, in the bank. Finally, the economical shift, you could see that is shifting to intangible assets. I remember there was a survey that was done years before 2025. The physical assets was like 80% and intangible was 20%. By 2015, intangible assets have moved to 87%. And you see, with that, it helps investment, and it's taking, for instance, it's taking debt from bank debt, which is that is very costly. It's taking it and it's increasing the amount of finances provided by private debts. For example, the insurance one that I talked about, they can come and then you do you take out insurance for that without huge money. You can imagine going to take 250 million from a bank, what it will cost. So these are the new areas. And then like the insurance and all of that, lenders, it's easier to now look at intellectual property, look at the portfolio sale, and then use it to get money through private funding. And it opens great way for intellectual property and makes it more valuable. So I think it depends on the owner of the intellectual property to really canvas, explore, and find a way to bring value to your product and your intellectual property. And more importantly, protect it, because you would have registered it. You must keep it alive and keep it valid and protect it, and don't let any infringer take it, so that you just stay. If they try to infringe on it, you just back and get it back, so that you will not be adjudged for lashes and acquiescence, that you allow somebody to use your intellectual property for 10 years and you're now waking up to chase them. I guess I will stop here, and thank you.
Thank you so much, Mark, for a very insightful presentation. Before I introduce our next speaker, if you do have any question, please do type in the Q&A, and at the end of everybody's presentation, it will be answered. Our next speaker is Mr. Oyagbiola, who is a principal partner at Oyagbiola Chambers, and he will be speaking on managing IP portfolio, nuts and bolts of due diligence. Thank you so much, sir, for joining us today. Can you hear me, sir?
Thank you. If you don't mind, I'll share my screen so that I can show my slides. Okay, 1 second. Okay, can you see my screen now?
No, sir.
Perhaps you need to give me permission to share, because I clicked on the share screen, but it doesn't seem to be sharing it. Or I sent it to you when the last speaker started speaking. So if you want to share it yourself.
Let me try doing that, sir.
Okay, hold on, let me see. Actually, I think I've got it. Is it coming on?
Yes, sir, it is.
Okay, thank you.
You're welcome.
Okay, good afternoon, everybody. It's nice to be with you all today. Now, I've been given 20 minutes to talk about managing IP portfolio, nuts and bolts of due diligence. That's a bit of a tough ask, 20 minutes, but I'll try my best. I believe that the audience is a fairly high level one, people who already know about intellectual property, but I think I still need to situate the essential nature and types of intellectual property before I move on to talk about managing due diligence. So let me start with that. What is intellectual property? Okay, one moment. Now, intellectual property, as even the last speaker said, is clearly an intangible property type. It owes its existence to the protection of the law. I'm going to run through this very fast. So I have set out the attributes of intellectual property, and broadly, they are the fact that it's intangible, it's a product, or they are products of the intellect. They usually, but not always, have a finite existence. I say not always because, to just use a quick example, Coca-Cola has, for well over a century, protected its trade secret, the formula for what it mixes to make Coca-Cola. Finally, some intellectual properties, not all, require formalities. They require registration. A clear one that is clearly, that does not fall within this category is copyright, because copyright comes about by the very act of creating something. You do not need to go and register to be given copyright. So if I write a book, the fact that I've published that book gives me copyright in that book. What are the different forms of IP? What are the forms it can take? I've just put them under 4 broad umbrellas: patents and designs, copyright, trademarks, and trade secrets. I said broadly put them under those umbrellas because patents and designs actually constitute 2 different forms of IP. So what are patents? Patents are granted for inventions, processes, and methods. And they are granted for things that fulfill certain, that are able to exhibit certain attributes. The main attributes usually are said to be 3. The invention or the thing that has been, or for which a patent is sought, must be new, as novelty. It must be innovative. That is, it must be creative. It cannot be some mundane thing that has been done, and it must have some use. Then industrial designs. That's the second part of patents and designs. Industrial designs are designs that are registered. Usually they are to do with, for instance, although architects don't always do that, architects can register their plans or their architectural drawings, but usually 2-dimensional and 3-dimensional representations of something. That is what you can register in the registry of designs, of industrial designs. Then copyright, I've already spoken about copyright and the fact that it does not need to be registered to come about as a right. It comes about merely by the act of creation. Let me quickly go to trademarks, which is any word, phrase, symbol, or any set of them that are used to represent a product in the marketplace. Again, Coca-Cola is a good example. Pepsi-Cola is there. Sometimes you come across situations in which trademarks become generic. A very good example that is often brought about is trampoline. Trampoline used to be a trademark, but is now used as a name for a type of product. The same thing goes for a refrigerator, for instance. So that's one of the things that you have to carefully watch against. Coca-Cola almost got there, because that's perhaps why the makers of Coca-Cola always tell you that Coca-Cola is the trademark of the Coca-Cola company. They say that because they do not want Coca-Cola to become a generic name for that kind of drink, although in my opinion, it is more or less already there. Then you have, one moment, trade secrets. Now, trade secrets are of a slightly different nature from the others because trade secrets are merely the accumulation of the things that a business or a person does. They can be as mundane as merely a phone list of customers, but they have commercial value and they are protected by the law, provided they are taken from the owner improperly. If by some chance you are able to actually come about the same list all by yourself, then the owner of the secret can no longer invoke anything against you. Trade secrets, let me just say this. Trade secrets may come about through contract, by the signing of non-disclosure agreements and various things like that, or it can come about through equitable means. For instance, if you go to meet a person and you and he reveals some things to you with your knowledge, or with you knowing that he does not intend you to use them for yourself, then you are duty bound under the law to keep those secrets and to not use them for your own benefit. Now, when we talk of managing IP portfolios, what do we mean by an IP portfolio? And the answer is simple. It is a collection of the entire set of intellectual property rights that belong to a person, or perhaps a company or group of persons. So it can be any of the different ones I've already mentioned. And all that is required is that they are brought together. For you to bring them together, obviously, you must know what they are. And that is part of what we are going to talk about. Now, for you to properly manage an IP portfolio, you need to understand what you want to do with your IP assets. You need to have a strategy for managing IP. You need to identify what you want to do with the IP you want to manage, and you need to know how you want to make money from it. Now, those are things that that the previous speaker spoke about. What are the measures that you need to take broadly to manage your IP portfolio? You need to register the ones that are registrable. These include, of course, patents, trademarks. In some cases, you may actually need to notify others. That's not quite registration. You may need to notify others of the existence of your intellectual property. There is an interesting bit of anecdotal knowledge that I came across some time ago. They said in the days before they started the first patent registry, the way people protected their creations was to write out the details of the creation, put it in an envelope, stamp the envelope, take it to the post office and post it to themselves. That proves the time of making, because time is important. If you are the first to make something, then you are the one entitled to a patent, and not someone who made it later. So the second thing you need to do, you need to ensure that you put protection clauses in all your agreements. So if there is any agreement you are getting into in which some of your secrets or your valuable intellectual property assets will become revealed or exposed, you need to make sure that you put in clauses to protect yourself. You need to also ensure that policies are in place in your office or workplace, your business, to ensure that employees, your contractors, third parties, or whoever you are dealing with does not make away with your intellectual property. For example, I just spoke about customer lists. If someone comes to work for you and you fail to extract a promise in their contract of employment not to disclose your list of customers, you may be exposed. Then you need to regularly monitor your IP assets to ensure that you are able to know when they may be being exploited by others, so that you can take early action. Now, of course, if you do not take action in time, you may be exposed to limitation provisions, so that you may find that at the time you now decide that you want to stop the use of the thing, you may no longer have a right of action. And then you need to ensure that you continuously train all your people, all your employees and your partners to ensure they know what they need to do to protect your assets. As we have said at the very beginning, they are intangibles, and therefore it is only through knowledge, telling others that you have them and that you are going to protect them, that you can continue to protect them. What is due diligence? Now, due diligence means the investigation of all the aspects of aspects of a thing to understand and to know how you are going to protect, to know its value and to know its worth. So when we talk about IP due diligence, we are talking about being able to know everything about your intellectual property. Because again, let me reiterate that if you do not know very clearly what intellectual property you have, you are not going to be able to protect it. And your right in the intellectual property remains purely on your ability to protect. So you lose your right to protect, or you lose a strategy to protect, then you've lost your property. One moment. So again, this is just continuing with the same thing. Your due diligence must be habitually carried out to ensure that the value of your intellectual property assets are kept up to date. Now, something that may be worth nothing today may very well shoot up tomorrow. It may be because someone else has brought out an invention, or it may just be that something else is new in the market that can exploit that which you already have. So that is one of the reasons, or that is a good reason to have to engage in due diligence in the first place. Importance of due diligence, again, to assure true value and avoid risks. What are the uses of due diligence where you have carried it out? Its use is again to determine total value, and often where someone wants to make an offer of their business, they need to know what assets they have in order to have a proper valuation of that business. So to facilitate an initial public offer of your business, to enhance the raising of investment capital, these are all to do with the value of your IP assets. And again, lastly, to facilitate the sale, purchase, or licensing of your IP rights. Again, it's to do with knowing the value of your IP assets. What are the things you need to do, or what are the preparations in order to carry out a successful intellectual property due diligence? The 4 things I have listed here are that you must prioritize the things you want to actually find out about. It may be impossible to actually carry out a total due diligence of everything that you can count as your intellectual property. So you must know which ones that you are trying to find out about, or the order in which you want to find them out or find out about them. Then you must classify them in order to know the steps you need to take in order to find out about them. Then you must know what steps you want to take to investigate. And finally, you must know what you want to interrogate in the results you get from your investigation. So let me start with the prioritization. What are the considerations you must have? You must know what your objectives are for wanting to carry out a due diligence. Obviously, the most important objective is valuation, but you must know why you want to value your IP assets. You must also know how your IP assets fit into your business plan, into your entire business, because that also helps to know what things you wish to investigate most closely. Then you must consider things like, for instance, whether your IP assets are being marketed, because then there are some things you need to investigate that maybe otherwise you would not if you are merely retaining them. You must know who and how the assets are being enjoyed at the present time. You must investigate whether your existing protection strategies are sufficiently strong or robust. And then you must also be able, and this is all part of your investigation anyway, you must be able to find out what types of transactions you have engaged in, because that is how you are able to know whether you have in some way exposed your assets without your knowing so at the time, and to consider whether there are steps you can take to reverse whatever harm may have been done. Now, I said you must classify your assets, and I'm talking about the classifications I've already spoken about into patents, industrial designs, copyrights, trademarks, trade secrets. They all have different attributes. So for you to investigate them, there are different things you must look at. To use an example, if you are looking at patents, you must again re-examine the novelty of the patent, that even if you've already received the patent, it can always be challenged at any time, because the fact you've been given a patent does not mean that a person who perhaps has been using that particular process that you've patented cannot challenge it and say that there was no novelty involved, or that it was already in the public domain before you put it out for patenting. Again, your industrial design, you must investigate whether perhaps there had been, perhaps the design you registered had been out there all the time. For instance, maybe you registered an Adire design textile, and it's found out that they've been using it for the past 2 decades. You cannot seriously think that you can protect that design. Copyright, again, well, that's more straightforward. To protect your copyright, you must show, or someone else must not be able to show that you've copied something he did. Even if you actually did the same thing, you have copyright, except against that person who also has it, provided each of you got it independently. So copyright is not about it being novel necessarily, but it must not be that you copied someone else's work. So sometimes there have been cases in which there was inadvertent copying. If you can prove inadvertent copying, like for instance, something was told to you without your knowing, or without your remembering, or you saw something no matter how fleetingly, and that was what actually led to your to what you now produced, then you cannot get copyright in it. So trademarks, again, trademarks you can get as long as you've done your, as long as your symbol or words or whatever has not been used in a trade and registered before. However, you cannot protect your trademark against someone who already had already been using it for his business before you registered that trademark, even if he did not register it. So he has to prove that he already had a reputation in the use of that particular symbol or set of words. There are still some difficulties with this. A lot of the difficulties have now been dealt with by international treaties, because in the past, I remember reading the case of someone who went to register, what was it? I think Harrods, somewhere in the Midlands in England, and wanted to retain the name against the big shop that we all know. He lost in the end, but it was touch and go. And that's because I believe he was able to show that he had actually been trading with that name for some time, but perhaps it was not long enough. Same thing with trade secrets. Your trade secret is a trade secret only as long as, or can only be protected by you against a person who has obtained it from you improperly, or given it to, or taken it from someone who obtained it from you improperly. So sometimes they always use the term something being in the public domain. If the particular trade secret is already in the public domain without anybody copying it or giving it to others, then you cannot protect it from those other people who are using it without getting it from you. So you must understand all the nature of all these things. And that's why protection is very important, because if care is not taken, you may inadvertently put your trade secrets in the public domain, and then you can no longer protect them. And then, of course, they lose value. So investigation. For you to investigate as part of your due diligence, there are certain major things or key factors that you have to look into. First of all, you have to look at the creator, and then you examine the ongoing risks and liabilities. You look at the validity and enforceability of your rights in the intellectual property, and then you look at current and ongoing ownership and the status and control of the intellectual property. I'll deal with each of these very quickly. IP asset creation. Now, it is not necessarily the case that the maker, author, or creator of an intellectual property asset is the owner. Most contracts of employment will tell you or put it there that any invention or creation made by their employee in the course of employment belongs to them, subject usually to certain compensation being given to that employee. But even beyond this being put in contracts of employment, it is often something that is inferred, something that is presumed, that a person who is in employment and has produced or created something in the course of their employment has to cede it to the employer. So it is important anyway, just to make sure that you protect yourself as an employer, that you make sure you put these kinds of clauses in your employment or in your contract of employment. And as an employee, you must make sure that when you are doing something and you do not wish it to pass to your employer, you must make sure that perhaps before you actually do the invention or create the new thing, that you discuss it with your employer, and perhaps you sign an understanding that it is for you. Obviously, for you to achieve that, it must not be something that is in the line of employment. So for instance, use an example, a lawyer who creates, a lawyer in employment who creates a medical device, it will hardly be presumed to have created it in the line of his employment. But if care is not taken, the employer may still have a right to it. So it is still necessary for such a person to discuss it with his employer beforehand. Risks and liabilities. By this, I'm talking about ensuring that your IP assets are devoid of any ongoing risks. So for instance, you must ensure that you register the registrable assets and you keep them registered. For instance, trademarks are registrable only for a finite period. Same with patents. You can continue to renew your trademark registration. For patents, it's not quite so straightforward. I think you can extend once in certain cases, but it's not indefinite. For copyright, you don't need to register anyway, but your copyright exists only for a finite period. There are also certain things, like for instance, morality may come into play. It's not very clear what the position of the law is on this, but there are certain things that will not be given the protection of the law. And the rules differ from jurisdiction to jurisdiction. But all I can say is that the problem does not exist when you talk about trade secrets, for instance, because the law, I mean, trade secrets are almost like shows this in action. You can only achieve protection by going to court. You do not register them. Therefore, what are you actually going to court to protect? It is either a contractual right or an equitable right. The point is that the court is not going to protect any contractual or equitable right that will tend to enforce immorality. Determining ownership and viability. I hope I didn't drop a slide. 1 moment. Okay, validity and enforcement. The world of IP is filled with potential pitfalls that may destroy your asset or make them invalid, which is one and the same. Just to give a random set of examples, one drawn from each of the classes of intellectual property that I have mentioned. A patent that is granted in which there is no innovativeness will be cancelled when that is discovered. So even if you already have your invention patented, or if you've received a patent for your invention, it is important from time to time, at least in the early years, to scrutinize to make sure that no mistake was made. And also sometimes, and this is often missed, sometimes to look at the next logical step so that you can also apply to protect it. Because what you have invented may also, an addition to it may be patented by someone else, as long as it's not an obvious addition. So if you want to avoid someone else riding piggy bank on your invention, then you should actually scrutinize your invention from time to time to see whether there's something else you can add. Maybe there are new patents you can apply for. There are people who have hundreds of patents in their names. Some are obviously useful, some not immediately useful, some never become useful. With copyright work, it's important that you ensure that it is not copied from anybody else. There is a case, I remember, do I remember their names? A Nigerian author who sued a very well-known international author for plagiarism because he copied a story he had written locally. He failed, unfortunately, although I think it was fairly clear that he ought to have succeeded. I think he made some mistakes in his action. Then talking about trade secrets, you have to ensure that your trade secret does not get into the public domain. I believe I've already dealt with that. Then when you are talking of trademarks, you have to ensure, you have to scrutinize that whatever product you have registered a trademark for does not become, or that your trademark does not get used in another jurisdiction for the same or similar type of goods as you have registered a trademark in, say, your own jurisdiction in Nigeria. So that's why certain companies, of course, you have to have deep pockets to do that, register trademarks all over the world. Of course, it's of no use if they're actually not taking their products into those other jurisdictions, because one of the principles of trademarks, the grant of trademark, is that it must be used. If it's not used after a while, it actually gets deleted from the register of trademarks. So determining ownership and viability. Now, I don't think I have time to run through all this. We are running out of time. So perhaps I'll just let you have a quick look at this. The important thing is you must, from time to time, check with relevant registry to confirm. This is actually determining that your ownership remains. It's not determining the initial ownership. So checking with the relevant registry for registration and the dates, identifying clear chain of title. So for instance, where licenses have been given or assignments have been done, you have to make sure that the assignments have been properly notified to the assignee, or to the assignor. Sorry, I'm mixing things up. Depends anyway, let me leave that. You need to make sure anyway that your assignment is legal. There are very clear rules about assignment which you should follow. Then you have to have information on previous owners so that none of them is able to come back to claim anything. You have to make sure of the title of something that you are actually acquiring from someone else. Well, I believe you've seen all this. As I said, I don't think I have time to go through each of this in turn. In relation to trade secrets, I think I've spoken about all this. you have to scrutinize, make sure your agreements are properly made. You have to make sure that all precautions are put in place to restrict disclosure and to make sure that if there is disclosure, the disclosing party is liable to be punished in substantial damages to make up for perhaps losses to you that may result from your trade secret getting into the public domain. If you can trace the trade secret, if you can trace that your trade secret has passed from someone who took it from you improperly to the end user, then you can still proceed against that end user. But if you cannot, that end user is free to use it. So you have to go back to the person who passed it on. So in relation to software, software, of course, is a special type. If someone is going to sell software to you, you have to scrutinize things very, very carefully to ensure, and I think this is the most important, to ensure that the software that they seek to sell to you has not been made open source, which means it's available for everybody to use. I think that perhaps is the most important thing. Then other things that you have to take, we are talking about the nuts and bolts. I cannot cover the field, but I can just talk about some of the small things you can do. You have to make sure you have a list of everybody that worked on a product to ensure that none of them is able to claim ownership as against you. You have to scrutinize documentation and also examine when changes were made and who made them. You have to know the status of each of the people who are involved in the making, and you have to basically have well-documented papers about the process of creation of the IP asset. So in other words, you have to maintain very good paperwork on your IP assets. That is very important because it is your paperwork that actually documents your ownership in many of the cases. Even if it's registered, if you are not careful, if care was not taken about the creation, your registration can be challenged by someone else who comes to claim that it is that the particular asset was made by them and not by you. So there may be issues with the results of an IP due diligence exercise. Where there are such issues, you have to deal with them very quickly. It's the same process as I've already spoken about. So you have to go through all potential defects to make sure that you are able to protect yourself against them. So we are talking about the same thing. This is a cyclical process that you have to continuously go through. So the owner of an IP asset has to always be vigilant. Vigilance is the name of the game. If you are not vigilant, you can very quickly lose your intellectual property asset to others, or even lose it as an asset. So, conclusion, I'll just leave you with this. In this innovation-driven era, the protection and administration of the company, 1 second, this is I just, sorry. 1 second. Yeah, in this innovation-driven era, the proper protection and administration of a company's intellectual property portfolio is critical to driving its business needs and its business assets. A carefully structured approach is necessary to ensure that all risks are identified in time, mitigated for, and cured, so that all the expectations and objectives of the company from its IP assets are fulfilled. Thank you very much.
Thank you so much, sir, for such an insightful presentation. So if you do have any question, please do type in the Q&A and to be answered after each and everyone's presentation. Our third speaker is Mr. Okoye, who is the IP and Technology Legal Director of Olajide Oyewole LLP, and he'll be speaking on managing IP portfolio artificial intelligence as assets in business transactions. Over to you, Mr. Okoye.
Thank you very much. I'll stand on existing protocols. Sorry, Mr. Adebayo. Okay, I was going to ask if that could be taken down. Thank you very much. I believe that the context in which I was going to handle this topic was from the perspective of ownership of IP vis-a-vis artificial intelligence and products that are the outcomes of AI programs, and what is the scope of ownership where those works are concerned. So I'll just quickly share my screen. Please let me know if you can see my screen.
Yes.
Okay, thank you very much. So we are pressed for time, so I will just take a very quick dive into some of the issues. Now, we've had extensive discussions, and thank you for the previous speakers for taking us through all the various aspects of IP. Now, I am looking at it from, like I said, the concept of ownership. Now, as you can see, Section 2, Sub 1 of the Copyright Act provides that copyright shall be conferred on every work eligible for copyright, of which the author, in the case of a work of joint authorship, any of the authors at the time when the work is made is a qualified person, that is to say, is an individual who is a citizen of or is domiciled in Nigeria. So that presupposes that we're talking about a human being that is a Nigerian, or a body corporate that is incorporated under Nigerian laws. Another key law is the Patents and Designs Act, and under Section 2 of that act, it vests ownership in a patent in a statutory inventor, which also presupposes a human being or a body corporate. The trademarks is quite similar in that respect. Now, I wanted to just quickly, yes, the speakers have talked on all the issues, like I mentioned earlier, but I just wanted to talk very quickly about the key benefits of having an IP portfolio. One, obviously, is that it creates a barrier to entry. And what do I mean by this? I mean that it effectively stops competitors from, yes, that's where I am. So it effectively, for example, holding a patent around a new technology involving a product will stop other competitors from entering into that space and selling products that are similar. Basically, what we're trying to say is that a well-managed patent, for instance, creates a protective space that keeps or shuts others out. There's also the issue of attracting investors. So once you create a barrier of entry, what would typically happen is that investors will be more interested in investing in that business or that enterprise because they understand that you have the exclusive space within that market. And that is key if your market position is crucial to your business strategy and if you want to attain longevity within that space. So your IP portfolio shows them, i.e. the investors, that you have a vested interest in your company, in your product, and in your invention, or what have you. And then there's the issue of added value. So a comprehensive IP portfolio can make your business more valuable than your competitors. So it increases your profits. If someone wishes to buy any IP assets related to your company. I remember a couple of years ago, we were involved in one of the biggest deals in the entertainment space at the time, where a foreign investor came to acquire a local business in the entertainment space. And one of the key considerations for that deal was the IP portfolio of the Nigerian company, which was, by the way, very extensive. So all these factors are crucial to any IP owner in order for you to benefit from them. Okay, so very quickly, I am tasked to talk about vis-a-vis IP. I'm tasked to talk about artificial intelligence. And while I was reading up on artificial intelligence, it was very interesting to me, particularly the fact that AI emerged as far back as the 1950s. And that's very, very interesting. And when we talk about AI, what are we talking about basically? It's the ability for a digital computer or a computer-controlled robot to perform certain tasks that are commonly associated with intelligent beings. So AI basically is an umbrella term that refers to various programs and functions that are created with the intention of simulating, this is key, human intelligence through programming. Now, some of the tasks and activities that are performed by AI, and I can just reel out a few, are like speech recognition, handwriting recognition, planning, problem solving, which is crucial, image analysis, and what have you. Now, how does it work out? Artificial intelligence relies primarily on algorithms, which function like automated formulas of thought. Now, what am I talking about? In a very general sense, an algorithm is a set of instructions that instructs a computer on how to transform a set of facts into useful information. The facts, let's look at them as this, are the data, and then the useful information is the knowledge that you and I, people, that the machines themselves can utilize. There are many common examples of algorithms, from sorting out numbers to finding routes on your maps, from displaying information on your screen, and so on and so forth. Now, to get a feel of what the concept of algorithms is, just think about this. When you get up in the morning and you get dressed, some people don't give it a second thought, at least I don't. But imagine you have to write down the process of getting dressed, or you have to tell a 5-year-old what the process of getting dressed is, such that he or she understands. That's similar to how an algorithm works. And there are two key components in an algorithm. So there's the learner which assimilates the data given to the program, and then there's the classifier, and both work hand in hand. And what does the classifier do? It organizes the data into classes based on computer values, and once it has been able to classify the data, it can then make predictions based on the classifications or the trends that it has seen in the course of classifying that data. Let me give you an example. You or I, the human user in this case, we input data into the computer. The computer analyzes the data and looks for a pattern. When the computer finds a pattern, it adjusts how it processes or manages the data to reflect how it is found. After the computer finds enough patterns, it can then begin to make predictions. So what this means is that if a larger amount of training data is imputed, the computer would therefore become more accurate in making those predictions and also faster in doing so. That is now what we refer to as machine learning. So it learns from all the imputed data, and then it can make those accurate or similarly accurate predictions going forward. So yes, I gave a very simple example, and machine learning is a little more complicated than that, but those are the basic steps that are required. Now, why is machine learning a key differentiator or a game changer? Through machine learning, artificial intelligence is not only able to handle large amounts of data at a much faster rate, but is able to perform autonomous improvements, and that is crucial. On its own, it can perform autonomous improvements based on what I said earlier, which is the identified characteristics, the identified classifications, the identified patterns, the identified trends. And then on that basis, it can move forward with the predictions. That is precisely why it is a game changer. So now, what are what are the common uses of artificial intelligence? As I said earlier, it has been around for a while now, and yes, it is becoming more and more popular, but that's the fact. Now, from predicting customer behavior to reducing crime to giving customer trends and suggesting purchases online and influencing customer behavior, the fact is that AI is used in virtually almost in all industries available. And the use cases are multiplying exponentially. It hardly comes as a surprise, considering that with AI, you can make the user, you can make decisions much faster and much more accurately than before. And while using AI is still relatively new, it has, like I said earlier, multiple business applications. So it's a very, very important and critical tool to businesses right now. And why are we talking about this in the concept of IP? It's because, like I said in the beginning of my presentation, that for you to be able to, I was looking at it from the perspective of ownership, for you to be able to assert any right over any IP work or enforce any rights or exploit any rights, there must be an element of ownership, either as the first owner or as an assignee or as an exclusive licensee, and so on and so forth. Okay. Now let's look at this from the perspective of innovation and creativity. So since the 1970s, computers have been producing works of art. Yes, they were crude initially, and they've become better over time, but they've been doing so since the 1970s. And most of these computer-generated works of art relied heavily on the creative input of the programmer, so the person behind the screen. And the machine was merely an instrument in those instances, but today it's different. Yes, we're in a technological revolution that is underpinned by rapidly developed machine learning. So now what happens? A computer program developed for machine learning purposes has a built-in algorithm. Remember, I discussed algorithms earlier. That built-in algorithm allows it to learn from the imputed data and then evolve and make future decisions that may be either directed by a third party, i.e. the programmer, or maybe totally independent. Now, when it comes to art, when it comes to music, when it comes to literary works, machine learning algorithms learn from, it's the same formula. They learn from the same imputed data provided by the programmer, and then they generate new pieces of work. They make independent decisions throughout the process in developing this new work, such that the new work can be attributed to the AI. So a very important feature for this type of AI is that while programmers can set some parameters that can guide the AI technology, the work is generated independently, having learned from the input of the programmer. So the question is, what type of work is generated? Is it a neutral work, in which case nobody owns it? Or is it attributed to the programmer? Or is it attributed to the AI itself? Which takes us back to the definition of who owns the work, who owns the IP in the work. Now, and it's a very interesting conversation. So let's quickly look at it from a copyright perspective, for instance. Creating works of artificial intelligence will have very important implications for copyright law. Traditionally, the ownership of copyrights in computer-generated works was not in question because the programmer, like I said earlier, the program itself, rather, was merely a tool that supported the creative process. Very much like the pen and the paper is a tool that the writer uses to express his art. Now, creative works qualify for copyright protection as the previous speaker said, if they are original. Now, with most definitions of originality requiring some form of human author involved. Now, it will interest you that in jurisdictions like Spain and Germany, what their laws provide is that only works created by humans can be protected by copyrights. Now, those laws may change anytime from now, given the pace at which technology is developing, but that is where we are. With the latest types of AI, the computer program is no longer a tool. It actually makes the decisions involved in the creative process without the human intervention. And this is something that is extremely important. Now, one could argue that the distinction may or may not be important, but the manner in which the law tackles the new types of machine-driven creativity could be far-reaching and could have very serious commercial implications. Now, artificial intelligence is already being used to generate works in music, in journalism, in gaming. These works could, in theory, be deemed to be free of copyrights. That's one school of thought, because there was no human factor involved. But there's the other school of thought that argues that no, perhaps the AI could actually own the work or the IP in the work that is created. As such, if it is considered to be free, then obviously it can be reused by anyone. But think about it, if it is free, then this will be bad news for the companies that sell these AIs. Imagine if you invest millions in a system that generates music for video games, only to find that the music is not protected by law and can be used without payment by anyone in the world. What would be your approach? So there's also that to consider. Now, while it is difficult to ascertain the precise impact that this would have in the creative industry, for instance, it may well have a chilling effect on investments in automated systems. So what do we then do? What's the solution? There are two ways to look at it, there are two ways in which the copyright law could deal with this situation. In other words, with works where human interaction is minimal or non-existent. It could either deny copyright protection in the works that have been generated by the computer, or attribute authorship of such works to the creator of the program or to the program. Those are the three, yes, three, not two. There are three broad options. And the way to go, these issues are still up in the air, and with the developments in AI over time and the law, and the involvement of the courts, we would have a better vision in terms of the way forward. It will interest you that where patents are concerned, because AI programs can create works that are unique, that are new, and so on and so forth, and eligible to patent protection. In some jurisdictions, patent applications have been accepted for filing in respect of AI-generated inventions. Now, that's a slightly different scenario to copyright. So basically, what are the things that we need to consider going forward? What impact, for instance, will AI technologies have on innovation and creativity? For me, it's too early to say. But it is clear that AI will have an impact on traditional IP concept. There's no doubt about that. Now, looking at it from commercial AI-generated music, like I mentioned earlier, or generated inventions are not far off and will transform the concepts of composer. Remember, we were looking at it from the perspective of the owner, composer, author, inventor. Yes, it will. But again, how it will happen is still up in the air. And the steps that are taken in the developed countries and here in this part of the world will determine what would play out. Again, there's the fundamental goal of the IP system, which is to encourage new technologies and creative works and to create a sustainable economic basis for inventions and creations. That is crucial. And in any arguments about who owns what, this would definitely need to be taken into account. And then finally, from a purely economic perspective, if we set aside other aims of IP, such as economic reward, moral rights, particularly where copyright is concerned, is there a reason, and this is a rhetorical question, is there a reason why we shouldn't use IP to reward AI-generated inventions or creations? Your guess is perhaps as good as mine. So like I said, it's an emerging area. It's a new area, even though AI has been around for a while. Unfortunately, where we are with our own laws is, it leaves a lot to be desired. I know in the last 12 months, there has been some traction where the review of the copyright bill is concerned, and recently, very recently, in fact, the review of the trademark bill is concerned. But then again, the results are almost discouraging. So it's all hands on deck, because we have to work together to move our laws forward. And these issues must be at the back of our minds when we're proposing reviews of our laws, so that we can cater for the new and emerging area and make sure that we're clear on where we need to go. Thank you very much.
Thank you so much, sir, for a very insightful presentation. Our last speaker is Mr. Luko, who is a partner at Truman's Rockwell Solicitors, and he will be speaking on dealing with IP lawsuit. Over to you, sir.
Thank you very much. It's a pleasure to be here. Once again, my name is Falari Aluko, and I'll be speaking to the topic, or I like to think of it as I'll be leading a conversation on dealing with IP lawsuits. The topic, the title, dealing with IP lawsuits, is a very wide one. It comes up as very wide, because there are so many angles that one can approach it from, slice it from. But what I decided to do is to quickly do a brief overview of what intellectual property is, and the run-up towards the conversation about IP lawsuits generally, and then we'll look at, or I try to look at 5 areas that I think one should consider. I'm guessing that many of those of us who are on the Zoom are lawyers, and so we'll look at a couple of things that one should consider when filing an IP lawsuit. First, let me say thank you to ESQ for putting this conversation together. I would also like to say a big thank you to all the previous speakers for doing a very fantastic job. If if I repeat anything that has already been said, please, I take all the responsibility for that. Kindly forgive and forget. So very quickly, what is intellectual property? The term intellectual property, just to confirm that we cannot see my screen. Okay. The term intellectual property refers to creations of the mind, such as inventions, literary and artistic works, designs and symbols, names, etc., images. I find we're talking about some concepts that are very big, and if you may, I won't consider to be misnomers, like intellectual property. What does it really mean? There are schools of thought that believe that the phrase intellectual property itself is a misnomer, in the sense that it does not accurately describe, what we refer to, the types of works that we refer to as intellectual property today, because the phrase was coined about 200 years ago, and of course the scope and the definition of what is IP has considerably broadened, over the past 100 years, considerably beyond perhaps what was considered to be, what was referred to as intellectual property when the phrase was first coined. Artificial intelligence, I think, is another such redundant phrase, because if you ask yourself, intelligence is intelligence. How does intelligence, what type of intelligence is artificial? If it is intelligent, then it's real intelligence and not artificial. But for the purpose of this conversation, IP refers to creation of the mind. And the distinction between IP and IP rights. IP rights, according to the World Intellectual Property Organization, allows people to earn recognition of financial benefits from what they invent or create. And the purpose of IP laws is to strike a balance between the interests of innovators and the wider public by fostering an environment in which creativity and innovation can flourish. And so it's important to, when looking at the concept or when having a conversation about IP, to realize that the IP itself is different and distinct from the intellectual property rights. The IP is the intangible property, the item in itself, while the IP right is the legal regime or the legal right that protects the intellectual property. It's I'll explain why this distinction is important later on. And so, for example, there's a distinction between an invention or an original work of authorship, like a book. So, for example, that distinction between a book, things fall apart, and the copyright in the book. There's a very, very sharp distinction. And we find that a lot of people, and we'll come to that in the course of later on in the presentation, because that the understanding the distinction can be the difference between losing a case or having a case struck out, and winning a lawsuit. So in the same way, there's a distinction between the invention itself and the patent right or the letters patent. So intellectual property rights create a composite or a bundle of rights to do something or to stop others from doing various things. When talking about IP lawsuits or IP rights, we're referring to a very wide scope of subject matter. And so as much as possible, I'll try to use generalizations, but there are some generalizations, one of which is the fact that, as Mr. Oyagbola had said earlier, that intellectual property is incorporeal, it's intangible. So again, some statutory rights create a composite or a bundle. Others stop others from doing certain things. Some give the author or the owner the right to do certain things. But at the end of the day, you have a situation where the law creates by statute some rights, and then by common law some other rights. The law generally permits an IP owner to also deal with these rights singularly or as a composite. Now I have a list of the sources of IP law. This list is not exhaustive, but it contains, I think, the primary legislation, including the new, I'll just correct that, the new Plant Varieties Protection Act 2021, which was assented to in April 2021. So starting from the Constitution of the Federal Republic of Nigeria to the African Charter of Human and People's Rights, there's a huge conversation about I've been trying to start a conversation around the right to ownership, whether there is a right to own movable property under the 1999 Constitution. I would like us to look at the right to own immovable property, which the Constitution provides, and then the right to compensation for the compulsory acquisition of movable property. That's a different conversation. So intellectual property is property, and there's a distinction between intellectual property and an intellectual property right. The intellectual property rights are created by law, and that law can either be a statute, as in the case of the Patents and Designs Act or the Trademarks Act or the Copyright Act, or it could be, or the Plant Varieties Protection Act, for example, or it could be, it could originate from common law, as in the case of the common right of passing off, or fair trade, and any of the other image rights, which is considered to be a common law phenomenon in Nigeria. So, yes, there are a bunch of at other intellectual property rights. This list is not exhaustive. Geographical indications, trade secrets, traditional knowledge, utility models, and so on and so forth. But suffice to say that intellectual property rights that are created by statute are created by the laws of the state. And so you have a situation where the rights exist at the level of the country, of the state, and in some cases at the level of the region. So, for example, you cannot enforce you can't directly enforce a work, or the copyright in a work that was created in Nigeria in another country, unless there are other certain realities, that certain factors must exist before a work that is protected in one country can be enforced in another country. Or a trademark registered in country A, cannot be enforced in country B unless certain, for purposes of trademark infringement, unless certain requirements are met, or the mark is brought, the lawsuit is brought as an action in passing off or something. So then the question is, what then is intellectual property? If there's a distinction between the intellectual property and the intellectual property rights, which can be enforced by way of a lawsuit, what then is intellectual property? Intellectual property is an asset. An asset is a resource that is controlled by an entity, to be a company or a business or an individual, as a result of past events, and from which future economic benefits are expected. So it's essentially, an asset is something that brings value, that can create value, and that has value. And so IP assets, as we said, are a type of intangible assets protected by law, which can be enforced against third parties. And they are independently identified and are transferable and have an economic life different and distinct from their legal life. Now, this foundation is very important because the objective of an IP, of the IP lawsuits essentially center around either the economic function of the intellectual property or the moral function, the protection or the exploitation, either one of the two. Now, when one says that while having a conversation about IP lawsuits, immediately presupposes that a dispute has arisen, and that parties have chosen to explore what you may call parties have decided to explore very aggressive is not the word, but yes, parties have decided to explore the option of non-amicable resolutions. Yes. And so these lawsuits can arise from a wide variety of situations. It could arise from the breach of terms of an agreement, or from an infringement claim. Section 5 of the Trademark, TMA means Trademarks Act. Section 5 of the Trademarks Act defines the scope of protection that is granted to a mark that is registered under Part A of the register. Section 15 of the Copyright Act, CA is abbreviated for Copyright Act, tells us what would amount to infringement of copyright. And so it could be for infringement, it could be for the enforcement of a moral right, as contained in Section 12, which Section 12 and Section 13 of the Copyright Act, which essentially allow the copyright owner to protect the integrity of the work. It could also be for, an IP lawsuit can also arise for the purpose of the interim preservation of evidence of infringement, notably the Anton Pillar order. And we see, for example, Order 28 of the Federal High Court Civil Procedure Rules, etc. And it could be to restrict the importation of infringing or potentially infringing either brands or inventions that may infringe on an existing patent right in Nigeria. So IP lawsuits can arise from a variety of situations. And what I was looking for was contentions. There's a presumption that the parties have already moved beyond the point of an amicable resolution and are contemplating, or at least one party is contemplating using contentious proceedings. Now, for purposes of categorization, we can broadly categorize IP lawsuits into two very broad categories. We have, these are my categorizations, by the way, so kindly forgive me. You have the quasi-judicial proceedings, which essentially are proceedings before a quasi-judicial panel like the Trademarks Tribunal. And quasi-judicial proceedings include, examples include the trademarks opposition proceedings, an application to a copyright inspector, Section 38 of the Copyright Act, appeals from the decision of the trademark registrar, Section 18, and so on and so forth. There are quite a number of such applications under the Trademarks Act, for example. It could also include, and then you have judicial, so you have quasi-judicial proceedings, and then you have judicial proceedings. Now, I should also mention that in certain circumstances, the Federal High Court acts as an appellate court over the Trademarks Tribunal. In those situations, the Federal High Court's role should not be seen as purely judicial, but as an appellate court to a quasi-judicial proceeding or to a quasi-judicial tribunal or body. So the second broad category can be described as judicial proceedings, which really involve actions commenced before a court of first instance. So it could be the Federal High Court, or state high courts, depending on the nature of the intellectual property rights that is sought to be enforced. And these generally involve infringement actions or actions for the enforcement of the rights, etc. And so, having given that very broad background, I would like to just highlight 5 mistakes to avoid when prosecuting an IP lawsuit. The first mistake is what I call the fallacy of the big payday. And the fallacy of the big payday. I find that, okay, you find that, you find that in many of the lawsuits some lawsuits that are filed today, one finds that the damages or the amounts claimed as damages always appear to be very mouth-watering. I remember a couple of years ago seeing some suits filed by a very popular, as at that time, collective management organization that, filed a lawsuit asking for billions of naira for the use of certain types of works without any actual proof of the existence of actual infringement that amounted to that, the sum that was claimed. And one finds that this theme seems to run, is a common thread among some of the more common, at least the IP lawsuits that have been covered in recent times. A very recent one was the University's challenge case, which was overturned. The decision was overturned by the Court of Appeal recently. And in that case, the Court of First Instance had awarded about 700 million naira as damages for the infringement of copyright. And I asked myself, what's the value of the intellectual property? How did the lawyer who drafted that claim arrive at that figure? And it seems like there's always a presumption that, because it's intellectual property, one can claim, and because it's intangible or incorporeal, one can claim, the sky is the limit, and one can claim any amount, no matter how outlandish. But the reality is that the law does not calculate damages or does not treat damages as a big payday. Of course, we all know that the court is not in the Father Christmas. But specifically, if one looks at certain sections, for example, Section 15 of the Copyright Act, Section 15 sub 4 of the Copyright Act, one would see that there are special conditions under which a court will grant or would award exemplary damages. So oftentimes it will involve, or it's the court will look at the general circumstances of the case, including the flagrancy of the infringement, the attitude or the behavior of the person who is alleged to have infringed, and so on and so forth. And it's the same thing with any of the other trademarks, any of the other intellectual property rights, trademarks, patents, industrial design, and so on. The idea is that the court will not grant some very large bogus amount. I've had the opportunity of speaking with, sometimes speaking with potential clients, or while interviewing potential clients. Someone says, "Oh, XYZ person took my son or stole my son, and I want to sue them, and I want to sue for X billion," an amount that one knows that perhaps even the person who is being sued cannot afford. How does there's actually a specific, there are a very specific set of principles that are to be applied in determining what is claimed, either as general damages or as special damages, and so on and so forth. So with intellectual property, with the claims, when drafting the claims, there's no big payday. It's always better to ground one's claims in fact, and as much as possible to link that fact with any actual damage suffered from the infringement, or from the behavior complained of. Another mistake to avoid is failing to explore mediation and alternative dispute resolution. In most situations, especially with regards to industrial property, patents, industrial designs, trademarks, time and cost, long-term cost, are a very huge factor. And even in entertainment, when one looks at certain industries, the music, movies, and so on and so forth, you find that there's a huge emphasis on time and on the speed with which disputes are resolved, and also on the ability of the parties or whoever is engaged in a lawsuit to recoup their money or to spend as little as possible in that lawsuit, because companies really are registered to generate business and not to engage in lawsuits, and whatnot. So it's important. It's very important as a strategy to always look for ways to explore mediation and alternative dispute resolution, even in opposition proceedings. Even in opposition proceedings. A third mistake to avoid is mixing up IP, modeling up or mixing up the idea of intellectual property with the intellectual property right. Very, very important. As I had said earlier, the distinction between, there's a clear-cut distinction between intellectual property and the intellectual property right sought to be created. When one models up when there's a mix-up, it affects it alters so many things. For example, there are certain foundations that must be laid when making a claim for over, or when making a claim in relation to certain types of IP rights. For example, or an easy example is when the distinction between copyright and industrial design. If one doesn't clearly identify or distinguish or situate the nature of the intellectual property rights sought to be created distinct from the IP, so it's a picture where it's an artistic work, for example, that is sought to be, the subject matter of the dispute is an artistic work, but the artistic work may be used as may either be an industrial, may be protected by industrial design if it qualifies for if it's to be multiplied over an industrial, if it's to be multiplied by an industrial process, in Section 1 of the Copyright Act, that distinction can be the difference between, either making a case for copyright infringement or industrial design infringement. I recall I represented a party in a case where there was a claim for copyright infringement, and the claimant's claim was based on an artistic work that was used on a product, like a T-shirt that had been mass produced. And of course, our first claim was that it shouldn't be a claim for copyright infringement, but for industrial design. And then ignorance of legal presumptions in IP is also a very huge pitfall to avoid. And what does this mean? Some very common or some very interesting presumptions. When one looks at one presumption is statements with copyright, for example, under the Copyright Act, statements made in an affidavit deposed to before a notary public are presumed to be true. That's something that one should take note of. Under the Trademarks Act, there's a presumption of validity that attaches to a trademark a trademark to which a certificate or for which a certificate has been issued. So what that does is it shifts the onus of proof from one party to another. So when a party that is claiming a certain thing does not meet or does not, when a defendant, or a plaintiff, whichever the case, does not recognize that certain legal presumptions exist either for or against their interest, it could be fatal to the case. And then finally, failing to prove special damages. In IP, I think that there's a case, it's Yemiton against, I forget the name of the case now, but the special damages must be proved specifically and must be proved specifically and approved as a question of fact. So it's not just enough for one to to allege. Of course, we know that general damages are damages for things like emotional things that cannot be quantified in specific monetary terms. So things like emotional damage and hurt feelings, etc., would fall under the general damages category. But then special damages, when claiming damages for infringement, specific damages for breach, those must be proved specifically, and evidence in terms of testimony or factual documentation or whatever must be tendered to show that this amount actually accrued as a direct function of the actions of whoever, of the defendant or the person on the other side. So very important thing to note. And yeah, so I think I would, we're pressed for time. I would draw the curtain at that point. And I would say thank you very much for having me. It's been an interesting conversation. I look forward to any questions or interactions.
Thank you so much, sir, for such an insightful presentation. Please, if you do have any question, please do type on the Q&A and to be answered shortly. So, I think there is no send it to callbyeswebinar@gmail.com. Thank you so much, Mr. Max. Hello, please, can anyone hear me? Yes, for those asking for the slides, please, you can drop your email address, then it will be sent to you after the webinar. Please, can anyone hear me? I don't know if anyone can hear me.
I think we can all hear you.
Okay, thank you so much, sir. Okay, in the absence of no question, we're rounding up today's webinar. Thank you to our speakers for such an insightful presentation and a profound section. Thank you for joining us today despite your busy schedule. I look forward to having you on subsequent webinar. A very big thank you to our sponsors, LLP, Farmview, GLIS and Co, Bloomfield, Advocate Law Practice, Everlaw Associates, and DOA for making this webinar possible today. Thank you also to our attendees. Okay, I think we have a question. Okay, someone just dropped his email address. Okay. Thank you also to our attendees for participating in today's webinar and to enjoy the rest of the day. So if you have any questions, because of the time, we can't take any question. Now, if you have any question, please do type. Do send it to callbyaswebinar@gmail.com. I'll drop the email address at the chat box. And for those asking for the slide, sent to you after the webinar. Thanks so much.
Thank you.
Much.
Thanks. Bye.
Thank you to our speakers. Thank you so much.
Bye.
Thank you very much.